You know, one thing about having a social media presence and making videos that I didn't think about when I started is I get a ton of emails and calls from other divorce lawyers in other jurisdictions that'll give me feedback on the video. I love your video, or did you think about this or that, or let's do a collab. And I start to dig into the laws of some of the other jurisdictions, both in and outside of the United States. I'm going to talk about Canada, our friends to the north, for a second, and a case that just I cannot reconcile how they came up with this decision. Stay tuned, you might learn something. Hello and welcome, everybody. In case you're new here, I'm Professor Noble. I'm going to talk a little bit about how laws are developed and a case in Canada that's still good law that just blows my mind. So again, in case you're new here, I'm Jonathan Noble, divorce and family law attorney, licensed in Pennsylvania and New Jersey. And in case you're unaware, laws are developed normally one of two ways. Either there's a statute that's written by the legislature of your jurisdiction. Here's a Pennsylvania divorce code. And they write laws with definitions. And it really sets out all of your rights, responsibilities, defines the law. You could see the legislative intent, what they're trying to do. But another very, very and critically important way that laws are developed is through appellate cases, right? That's when somebody has a lawsuit against somebody else and the trial court makes a decision, and then one or both parties file an appeal. And the Court of Appeal in most jurisdictions is an intermediate level Court of Appeal. In Pennsylvania, it's a Pennsylvania Superior Court, and a 3-judge panel makes a decision as to whether or not the trial court got it right. What's interesting is sometimes these decisions by the intermediate level appellate courts are split like 2-1. So it really could have gone either way. But in case you weren't aware, that's how laws develop. And divorce and family law attorneys and criminal defense attorneys and almost all attorneys, they look to the statutes and they look to the appellate case law, and they need to be up to date on both in order to guide their clients. Well, occasionally, I'll read a case from another jurisdiction outside of Pennsylvania or New Jersey, and occasionally from another country, and in this case, Canada. Now, you may or may not know that a few years ago in Canada, there was a case, Climans v. Latner, I think. Guy was ordered to pay $50,000 a month in support to a woman who had her own residence. And they didn't live together on a full-time basis, although they traveled together and they were boyfriend and girlfriend, but no marriage. He wanted her to sign a prenup and she refused. Then after they broke up, she sued him for support and won $50,000 a month in support, and he had to pay it. But there's another case out of Ontario that preceded that case. And I'll give you the site and I'll leave it in the show notes, but it simply blows my mind that if this was the law in jurisdictions where I practice, there'd be the floodgates of litigation would open, but it's the law in Canada. The name of the case is Stephan v. Stawicki, 2006, Can Law 2, 225, Ontario, Canada. Here's a copy of the case. And basically, what the appellate court said is we're not imposing or finding a bright line rule to determine whether or not these people moved in together. In this case, they still maintained separate residences, but the court refused to institute a bright line rule through its opinion. And that I found to be troubling because it did not create any certainty. Actually, it created more gray area than ever. And I'm sure that the case that was decided a few years ago relied on this case to some degree. But basically, the Court of Appeals in Ontario said, appellant submits that we should impose a bright line test and conclude that the respondent had not, quote, moved in and were not living together at that time. Then they go on to say that case law recognizes that given the variety of relationships and living arrangements, a mechanical bright line test is simply not possible. But what is possible? What is possible is either you're married or you're not. Either you went through the ceremony and took your vows or you didn't, which is the case in most jurisdictions that I'm familiar with and where I practice. And that's a good thing. Why? Because it brings certainty. One of the most important decisions you could ever make in your life is who you marry, right? Don't you want there to be certainty around that decision? Like, yeah, we had a ceremony, we got a marriage license, we took vows, we hold ourselves out as a married couple, we cohabitate together, we file tax returns together, we do all the things that married couples do. But in Canada, they don't think that. They don't think that way. They did not want to even define what living together in a conjugal relationship was, which is scary. Like at some point, somebody in this jurisdiction, in my opinion, someone's going to come forward and say, well, I always had my own place, and we were together once in a while in a conjugal relationship, and we were exclusive during those months that we were together, so that person owes me support. That's what's coming next if you read in between the lines. I cannot imagine how the floodgates are not just wide open in places like Ontario on this issue. If this was the law and there was this much uncertainty in places where I practice, the phone would be ringing off the hook to bring a support claim against somebody's former lover. It's just mind-boggling to me. Look, that's just one lawyer's opinion who practices in Pennsylvania and New Jersey. That doesn't mean that it's right for the people of Ontario. It just means that you really need to be aware that the courts in Ontario are not willing to make any sort of bright line rules, and they could easily do that. How? Either by statute, make a law that says you have to get a marriage license and you have to hold yourself out as a married couple in order to file a support complaint, or the courts of appeals can do it by issuing an opinion that says this is the bright line rule. You know, you have to be married. No more of this, you know, we're sleeping together and I maintain my separate residence throughout the entire time, but you could still file support if the facts are right. It's insane. Just my opinion. If you have an opinion, leave it in the comments. Share this with somebody who might not have their eyes open to some of these laws. And I don't know if Ontario is the only province that does this. I know that based on a conversation I had on my channel with an experienced attorney in Vancouver, you could just live together for 2 years and be in a common law marriage in British Columbia. 1 year if you have a child together, you're common law married in British Columbia if you're living together. Incredible, just incredible. Drop a comment, like, subscribe. Love to have you as part of the community. I don't see things getting better in Ontario when I read opinions like this. They ought to lobby the legislature to write a law that has no room for interpretation by the courts. So it's got to have a marriage license. You got to be married, or else you could be in a very short-term relationship with someone and be on the hook. And that's not fair either. Be careful out there.